Welcome back to Land Law Made Simple. This is our third session now, and today I want to have a look at co-ownership of land. So what happens when there's 2, 3 or even more people who are claiming that they have a right in the land or possession of the land. That's what will be our main focus today. So what is co-ownership? That should be pretty much self-explanatory. It just means that there are 2 or more people who own the same piece of land or the same piece of property. Can be a house, a flat, anything really, at the same time. Okay, so probably the most common example is when there's a couple who decides to move in together, so they buy a house, or maybe they only buy a little flat, something like that. In those circumstances, it's very common that people will just decide to put the house in both of their names. And so that would be a really common example of co-ownership. Now, the thing is, in law, it's a bit more complicated than that, okay? Every time there are more than one person, so I don't know, 2, 3, 4 people who own a piece of land or property together, the law automatically creates a trust of land, and that's under the law I've provided here, Charter 1996, or however you want to pronounce it. So that is something you cannot avoid. Automatically, there will be a trust that's being created. Okay. So what does this even mean with the trust? How can we understand this? Well, you can kind of think of it as 2 layers of ownership. Okay. The one is that we have the legal owners of the property. So that's the people who appear on the title deed, who are on the contracts, who've really completed the purchase and who handle all the admin work. So they've been buying the house, they've signed all the legal documents. Maybe they're the ones that created the mortgage as well to buy the house. All of this really official steps, or the admin and organization, that's the things that are being handled by legal owners as the trustees in the land. Okay. But then also, apart from that, we have rights to enjoy the property or to enjoy the land that people bought. So that means living in the property, maybe renting it out and getting money from the rents. Maybe you just have like temporary possession, those kind of things. If you are able to enjoy the value of the property in some way or another, then it will kind of indicate you're a beneficiary or beneficial owner. Okay, so 2 different things. One layer is the legal ownership, where you are on the title deeds, basically you handle all the admin work and so on. And then separate to that, the second layer will be who is entitled to enjoy the property and all the kind of advantages it might have. Okay. Now, obviously, very often the trustees and the beneficiaries will be the same people. So let's come back to the example of a couple who is buying a house because they want to live together. The legal ownership part will obviously mean they've bought the house, their names are on the title deeds, their names are on any kind of contracts, they've done all the admin work like signing the documents and so on. But then also, um, they will probably live in the house, or maybe they rent out the house and just use the money from the rent, but they're the ones who benefit from the property as well. So the most common example will be that the trustees and beneficiaries are the same people. Okay. Obviously, sometimes there's a difference. So, for example, if you have a parent who decides to purchase a property for children, that could be a case. So that is a bit less common, but it still exists, and it's very likely you will encounter some problem questions in exams where you need to decide who are the trustees and the beneficiaries and so on. Okay, so just as a little bit of an overview to make this really, really clear, what happens when we have trustees who are also the beneficiaries? Okay, so for example, we've got George and Heather who want to buy a house together as a couple. Okay, now both of the names go on all the contracts and the deeds, and both of the names are registered with the land registry, so they are the legal owners and they are seen as the trustees of the property. Okay. Now, in terms of the second layer with the equitable ownership, both George and Heather are also living in the house. They enjoy living there. They've got or a nice garden, for example, that kind of thing. So they are entitled to enjoy the value of the property, which means they count as beneficiaries under the trust as well. You can kind of think of it as people wearing two hats. So as trustees, they do all the admin work, signing contracts, handling mortgages and so on. And then maybe they put on a second hat, a second role, really, a second kind of personality almost, as beneficiaries, where they get to enjoy the property. Okay. Now, we have on the one hand side, when trustees and beneficiaries are the same people, they just take on different roles, but both of those roles rest in the same set of people. Okay. It can obviously be completely different, where trustees and beneficiaries are different sets of people. So, an example, we've got parents John and Mary who buy a flat for their daughter Emma, so that she can live in that flat when she starts university. Okay, so that could still be an example you might have encountered in real life. Must obviously be a bit more of a richer family, but still it does happen. Now, what is the difference now? We have The title deeds, they are on John and Mary. They are the ones who've handed all the contracts, who've sold the property, who've done all the purchasing, they signed everything. Maybe they had a mortgage as well, or the admin work was done by them. And then Emma, however, is the one who's meant to benefit, so she gets to live in the property. And maybe later on, once she's got a job, maybe she wants to have her own family, maybe she's moving somewhere for a job, she could sell the property and she can keep the money from that as well. Now here, obviously, we've got different roles by different people. So parents are the ones who look after the property and do the admin stuff. They don't have any right to live there, or they don't have any right to profit from the property unless the trust says so. And then Emma is the only beneficiary in this scenario, the one who gets to live there and enjoy all the benefits that come with it. Okay, so now we have another important distinction to make, and that is with legal estates and equitable interests and types of tenancies. So, as we've seen, the law splits ownership into two kinds: the legal estate with the formal ownership and the equitable interest. So who actually gets to use it, who actually has the entitlement of the real benefits, okay? Now, the legal estate cannot be split into shares. It must always be held by the trustees in something we call a joint tenancy. Okay, so possession is always something where even if there's more than one person, like a couple or something like that, who own the legal estate, that is always as a one unit, okay? And that's the joint tenancy, one unit of ownership, basically. The equitable interest, so the kind of people who get to benefit from the property, that is something that can be divided up. So for equitable interest, we always need to check whether this is being held as joint tenants or as tenants in common. So we will have a look at that, what that actually means in more detail now. But before we start with this, just a reminder from equity and trusts law. Who can actually be a trustee? If you had already done the trusts law modules, or maybe you are taking them at the same time as land law, you will probably already know this. Who can be a trustee? So trustees in land law must be 18 or older. It's a bit different to other trustees in like property law, I don't know, that kind of thing. In land law, they must be at least 18 years old to be a trustee and to be an actual like legal owner and to do all the admin, that kind of thing. If you want to give land to someone under 18, then by law it will always create some kind of trust where an adult person has to hold the property in trust for the child. Okay? And something to keep in mind as well in land law, the maximum number of trustees, so the maximum number of legal owners is 4. There cannot be more than 4 trustees or legal owners, which is probably enough most of the time. As I said, the most common example will just be a couple owning something, and yeah. But in theory, if there's more than 4 who want to purchase a house together, it's a bit tricky because only the first 4 adults that are being listed will count as the trustees, and the other ones will just be beneficial owners as well. I don't know what a scenario would be like that. Sometimes in exams you get scenarios where there's siblings purchasing a house together or some university students. So in that case it might be 3 or 4 or even more trustees, but to be honest, in real life the most common really is just a couple, so 2 trustees. What powers do trustees have? As we already said, the trustees or the legal owners, they are doing all the admin work, and they can pretty much do everything, like selling the land, getting a mortgage, buying different property, anything like that. So in theory, their powers are nearly unlimited. Why nearly unlimited? The thing is that they must consult the beneficiaries. So, for example, if we go back to our couple who's buying a property for the daughter, they can actually say, well, we've got a bit of a difficulty, we want to sell the land, because we're in financial difficulties, or maybe they want to, I don't know, make extensive changes, do some renovations, maybe they want to mortgage the property, I don't know, things like that. In that case, they must consult with the people who are actually entitled to enjoy the benefits. So the daughter who's living there does get to have a say in those matters. So the idea is that the legal owners or trustees need to try to follow the wishes, but only if it makes sense for the actual trust, and that is obviously a bit more of a difficult concept because it goes into equity and trust, so we will not really have the opportunity to look at that in more detail. But the main idea is that to keep the trust going and to keep all the money intact, to not lose any monies and so on. So sometimes if, for example, a beneficiary would say, well, look, I want to keep the flat as it is. I don't really have any kind of time to deal with renovations. It's going to be loud. I need to do my studying. How does it work? But it doesn't. Maybe those renovations and construction work are really necessary to keep the property safe. So it might make sense to go beyond the wishes of the beneficiaries for the sake of the actual trust property. Right, so now let's come back to those two ways of holding equitable interest. I said that there were two different types of equitable interest, or two ways to hold the interest. And the first one being a joint tenancy. What does that mean? In a joint tenancy, all the owners together own the whole property. There's no shares. It's not like, oh, this person owns the living room, this person owns the kitchen, this person owns the first bedroom, this one owns the second bedroom, nothing like that. There's no like shares or something. Everyone owns together the whole property as one unit. And the second element of that is something we call the right of survivorship, which means that if one owner dies, their interest goes automatically to all the other owners. It doesn't go into their will or estate. So even if they set up a will and they said, oh, I want the property to go to my son or my daughter or something like that, this will be void because it's a joint tenancy. It does kind of make sense if you think about it, because all owners are seen as a unit and all owners already own the whole property. So you can't take that away from the other joint tenants just because one party there is dying or something like that. Because everyone is entitled to everything, that is why the right of survivorship must logically apply. Example, Jack and Jay own a house as joint tenants, and so if one of them dies, so for example if Jack dies, Jay automatically will be the only owner of the 100% property. So that was always the case anyway, because each one of them was entitled to the whole property. Now the second way of holding an equitable interest is something we call the tenancy in common, and with this it works pretty much the opposite way. Each owner has a specific share. So sometimes it will be equal shares, so maybe we've got two tenants who each own 50%, or it could be unequal shares as well. So maybe one of the two equitable owners has a right to 80% and the other has 20%. So the main thing is to keep in mind that there are specific shares and people aren't entitled to own the whole property but just that particular share. And this also means that the right of survivorship doesn't apply. And if one person dies, their share goes to whoever is named in their will. Okay, so that's two differences which are kind of linked. Another example, let's say that Ben and Amy own a house, and we know that they are tenants in common and that they have unequal shares. So Ben has an entitlement to 70% of the ownership and Amy only to 30%. So if Ben dies, his 70% go to his children or wherever he named in his will, and it will not go automatically to Amy as the surviving tenant. Okay, so that's the two key elements each time you need to look at: the ownership and the survivorship, what happens when one person dies. What are the key things really that we need to examine, and which can tell us whether we are dealing with a joint tenancy and a tenancy in common? Obviously, we've got the ownership structure, so who owns how much of the property. In a joint tenancy, again, everyone owns everything together as a unit, whereas in a tenancy in common, you have different shares or distinct slices, and we can specify who actually owns what. Second element to look at is what happens when one owner dies. In a joint tenancy, as we said, the deceased share basically vanishes and all the ownership passes to the surviving owners, which is kind of a consequence of the fact that everyone owns the whole property together. And then in a tenancy in common, by contrast, we have distinct shares or slices which are owned by one person, and so because those are separate shares, those can actually be inherited. Then we also need to look at language that's being used in the contracts and trust documents. So in a joint tenancy, obviously because everyone owns everything together as a whole unit, there can't be any mention of any shares in those documents. That would be kind of a conflict, wouldn't it? Whereas in a tenancy in common, you will pretty much always find something like unequal shares or half each, or some kind of language that will speak of shares, or I don't know, different kinds of possession. But those things we need to keep in mind. There is a little bit of flexibility in tenancy in commons, where you've got unequal contributions, which are being recognized. Maybe one person paid like the vast amount of the purchase money and the other one only a little bit. So that's why tenancy in commons are a bit more flexible, and they can deal with those and just award different kinds of shares in recognition of those unequal contributions. Whereas in a joint tenancy, it's very rigid. Everyone owes everything together, and if someone dies, then the survivors just take up that share basically, and they stay own all the property. So I've provided here a little bit of a table, which might be useful for exams because it just lists the key things that are kind of hints whether we are talking about a joint tenancy or a tenancy in common. Joint tenancy, everyone owns the whole thing. It's just all in one pot being owned by one unit. There's no shares. We have the right of survivorship. You can't leave your share in a will or anything like that. And the typical users and typical examples will be just married or civil partners, couples, those kind of things who think we want to own this together as a unit. and if one of us dies, we absolutely want the other one to have the ownership. Okay, so that is a really typical use for joint tenancies. Now contrast this with tenancy in common, where there is distinct slices and each person owes a specific share. So maybe it's 20%, 30%, 50%, whatever. And because there are distinct shares, there cannot be a right of survivorship. And what happens if you have a will, you can definitely leave your share to the person you're naming in that will. Very often this will be quite clear in the deeds, because the deeds will speak of equal shares or even unequal shares, something like that, but there will be some kind of allocation of who owns how much of the property. And yeah, typically use obviously business partners who are purchasing a property together to run their business, or even friends or siblings or university students who maybe aren't even that close in some cases, so they don't really want to automatically pass all their ownership to the other tenants. So that is why it might be more convenient to have a tenancy in common with distinct shares that you can give to whoever you want to name in your will. Now, in law, obviously, if you have an exam, for example, you need to be a bit more rigorous in your approach and to apply this 4-stage test to really make sure whether something is a joint tenancy or a tenancy in common. Now, what are the steps we need to take in this test? The first one is to look at something we call the 4 unities. So the first unity would be of possession. So that's what I've been saying all this time. Everyone has a right to use all of the land. Okay, so that would be a really important marker of a joint tenancy, where everyone is entitled to the whole property and there's no shares that are being divided. Then another unity that would be absolutely necessary for a joint tenancy is that everyone needs to have the same types of interest, the same rights and obligations. Okay, it can't be that we have one person who's entitled to go into all of the rooms, for example, and then one person was only entitled to go into a little annex or whatever. Okay, so everyone needs to be able to access everything if there's a joint tenancy. Then title, that means that all the ownership is traced back to the same document or the same transaction. That is something that's also a requirement for joint tenancies, because this is a kind of seen as a unit, and so everyone needs to gain those ownership rights at the same time. And in the same documents. It's not possible that someone comes in later and just claims some kind of rights as a joint tenant. And that's what is also meant by the unity of time. They all must start at the same time in the same transaction. So if all of those 4 units are present, it just is an indicator that it might be a joint tenancy. But the main thing to look at will be express declarations in the deeds or any available contracts and so on. If the transfer document says very specifically that there are beneficial joint tenants, then that's conclusive, and we know obviously, okay, that's joint tenancy, case closed. Or if in contrast the transfer document says clearly in equal shares, you should have some kind of alarm bell going on in your mind saying, oh yeah, shares, I know that must be a tenancy in common. Again, another type of wording in transfer documents that should be an indicator is those kind of shares or half to A, half to B, those kind of things. Those we call words of severance because they make it clear that there are distinct slices which are different for each tenant. And then lastly, this is a bit more of a complex part of the test, and that's where we look at different presumptions that might be existent in equities or trusts law. Normally, the law will assume that there is a joint tenancy. Why is that? If you think back to the beginning of the lesson, we said that the legal ownership, so all the admin staff, the people who are on the deeds, all that size, that kind of layer of ownership, that's always joint. And so we say that the law presumes that the equitable ownership should also be a joint tenancy, and it only makes sense. It's just an aspect of the rule that equity follows the law. However, there are some exceptions where equity might say, well, hang on a minute, that doesn't really make sense in that case. And that's, for example, if there's business property, because people will probably want to pass the shares to their heirs, like children and so on, rather than to their partners when they die. And also another instance where we might presume a tenancy in common instead is when there are unequal contributions, so unequal contributions to the deposit or to mortgage payments and so on. So if one person is bearing a lot more of the price for the mortgage or the running costs, then that could indicate a tenancy in common instead. Let's just have a little bit of an example to see how this 4-stage test actually works and how you can apply it in exams. So let's just assume we have a couple, Sam and Priya, who decide to move in together, buy their first house. Now Sam earns a lot more money, and so he agrees to pay £90,000 to the deposit, whereas Priya, she doesn't earn that much money, so she can only afford to pay £10,000 towards the deposit, so a bit of an unequal contribution there. Now the transfer deed doesn't really mention any of the kind of key words we've been looking out for. It doesn't mention anything about joint tenants, but it also doesn't say anything about shares. And Sam and Priya, obviously they buy the property together. Both of the names are in the same transaction and they both get the ownership at the same time. And they use the property as their kind of family home. It's not a business property, it's just for private use. Now, let's have a look at the first step in this four-stage test, which would be to look at those four unities. So, for possession, we already know that both of them have a right to occupy the whole house. They live in that as their family house or a matrimonial house or wherever, and they can all use the whole property, all the rooms, the garden, everything. For interest, in the facts we've already learned that they both have the same type of legal interest, they have the same rights and obligations, and they both are owners of the freehold in law. We also know that both of their names appear on the transfer deeds and that they both got their interest from the same transaction at the same moment. So, if we look at the first step of the test, just the four unities, we can see, yeah, it's definitely possible that they might own the property as joint tenants. Because all of those four unities are present at the same time. So we then need to move on to the next step of the test, which would be to look at any kind of express declarations. In the prompt, it said that there was nothing in the transfer deeds that said anything like joint tenants or unequal shares or any kind of specific wording. So if there's no express declaration, we just need to keep going and move on to the next stage of the test. Rights of severance, again, there wasn't any kind of mention of any kind of allocations, who gets to own what amount of the property. There was nothing about equal shares. There was also nothing specifically about some getting more of the property because he paid a bit more towards the deposit. Nothing express at all. And that means we need to move on to the final step of this four-stage test, which would be to look at any of those presumptions in equity. You should remember that the general rule is equity follows the law, so there is a presumption that the equitable ownership rights are also in a joint tenancy. And the reason being is because that's what the legal ownership is always like. By law, the legal ownership is always a joint tenancy. However, there are some exceptions when the equity might say, oh, hang on a minute, that doesn't really make sense in this case. So we will say that it should probably be a tenancy in common instead. And those exceptions are, for one, if there's unequal contributions to the purchase price, or if there's a business property. Now here we know, wow, there are very unequal contributions. Some paid 90% of the deposit, and Priya much less, only 10% of the profit, 10k. So it's very likely that the courts might actually step in and say, No, we don't really think this should be a joint tenancy because of those unequal contributions. We will instead presume that this is meant to be a tenancy in common and that each person will get a share that's kind of equal to their initial contributions. So some, because you paid 90k of the deposit, so 90%, he will also get 90% shares, and then Priya will get only 10% because she paid a lot less money in the beginning when they made their deposit. So I hope this example makes it a bit clearer what the four-stage